Hello, welcome everyone, welcome. I'm just getting started here. It's taking a couple minutes to get set up. Welcome, welcome everyone. I hope this is okay. Let me know if you can't see the documents, if they're out of frame at all. I'll be happy to move them back in. Welcome, welcome. A little to the left. Thank you. How's that? Is that better? This is a little different than when I'm presenting in class. So, better, good. Okay, glad to hear it. Yeah, just keep me posted. I don't have students in front of me to tell me to move things, so I rely on the comments to make it known. So, welcome. I had attempted to do this live on Sunday, but that just did not work out. So hopefully the timing works out okay for everyone who's joining me tonight. This is a very interesting case that was just decided June 22nd, a couple of weeks ago by the U.S. Supreme Court on water rights in the Navajo Nation. I think some people may have known about this case, but it certainly, I'm not sure it got as much press as a lot of the other cases, but it is very important legally as we look through the water rights issues in the states, along with our Indian tribes. And of course, there are a lot of different titles for our Indian tribes, our Native Americans, American Indians. I will be using this term set out in the treaties, although, of course, probably not the best, but that's how it's referred to legally. So this is how I will be referring to it. But I do plan to go through the treaty that was signed in 1868 by the Navajos, and talking a little bit about the Colorado River water, which is really what this case is about, and a bit of the Navajo tribe location. I'll go into that a bit. I'll be talking about the law of the river just a bit. Also the Tucker Act, but most importantly, I will be going through the court's decision in Arizona versus Navajo. Hello, welcome. Welcome. Thanks for coming. I appreciate that. Well, hello. Thank you for coming. I had been hoping to get at least a couple of the prior cases posted before I went live tonight, so I did get some, but they haven't quite gone through yet. But I do want to go through this U.S. Supreme Court decision. Did I find the Dustin Turner case? No, I didn't. Although I do have a pretty extensive list. Let me just double check here while I'm getting everything set up. Okay, this was the Navy SEAL case. I've got it on my list. It's in the queue. It's on the docket. I'll have to get it set out. Yes. Yep, I've got it on my list for sure. I've got several things on my list. I'll have to really push through. I've got a RICO case on my list, so I've got several things, but thank you for reminding me. I'm so glad that you did that so that I can remember to get a video up on it. But tonight we're going to be going through Arizona versus Navajo Nation. And I'll just be summarizing this case and going through the important cases that were cited, along with the statutory law on how the United States can be a defendant. And then we'll talk about a couple of other cases that were really important. Off topic, how often do you paint your nails? Oh, oh, thank you. Oh, that's so sweet of you. You know, I really don't put a lot of time and effort into my nails. I probably should, but I just kind of go with simple and easy. Although I've seen a lot of nails done and they are just amazing, but I'm afraid that's just not too high on my list. I've got a lot of things to focus on. But I probably should, if I'm going to be having them on camera, I probably should be paying a bit more attention. But yeah, so tonight I'm hoping to give you an overview of some of the water rights issues that we're dealing with our Native American or indigenous peoples. Oh, thank you. Thank you very much. Oh, love that. Love that. Thank you. So I will go ahead and just start getting right into this case. Please feel free to ask questions as we go through this. I'm not expecting this live to be so busy that I won't be able to answer questions. Sometimes that does happen, but I don't foresee that being an issue, so I will try to make sure I stay on top of all the questions for tonight and answer to the best of my knowledge. This is a really tricky issue. It's a pretty big issue in the United States, of course. So I most certainly am not an expert by any means, but have read all of the cases and statutes and treaties involved. So I am going to try to just do kind of an overview, intro lecture really to what's going on in this case and why it's so important. But I won't be going through the exact language necessarily, but giving more of an overview. I think it'll be easier. And this case is humongous, and so it really, I think, is counterproductive to go through every single line. It's easier to just kind of do some summaries. So let me start off by saying, first of all, welcome everybody, welcome. I'm so glad you could join me. We had two Indian cases, Indian tribe, Native American, American Indian tribe cases that came down from the U.S. Supreme Court. One was Arizona v. Navajo, and this was decided June 22nd. The other case that came down, which was just a little bit prior to that, is the Highland case, and this came down June 15th. This was in regards to ICWA specifically. So I will be going through this case at some point, but tonight I wanted to really go through the Navajo case. The ICWA is the Indian Child Welfare Act. That's been a federal act that was put into place by Congress. So, but tonight we're dealing specifically with water rights regarding the Navajo Nation and the treaty that was signed in 1868 between the Navajo Nation and the United States. There are a lot of complicated issues, but I think I can summarize them here for you pretty well. So first, let's start with the location that we're talking about when we're talking about the Navajo Nation. This is the location here, and you can see it's in between Colorado, New Mexico, Arizona. California touches on the Colorado River a bit. That's why they're in here, along with Nevada and Utah. So it kind of is within this cluster of states, which brings up a lot of unique issues because every state has its own requests and its own problems that they want to deal with. So if you look specifically to the Colorado River, which is the water that's really, for on and on and on, been debated in court, we're talking about the Colorado River, and you can see it touches on California, it goes all the way down into Mexico. So we have this huge body of water that is really what's been contested repeatedly as access to this water. And they go into the upper Colorado Basin and the lower Colorado Basin. Now, I am not, oh, now that's just rude, isn't it? I am not here to give an environmental law lecture. That's kind of out of my jurisdiction. But I will at least give you just a particular boundaries here of what we're talking about. So this is the water that we're really talking about. And again, that really goes right through the Navajo reservation. So that's why this is such a big issue. We've had lots of different cases all the way back to the early 1900s and even before, talking about this body of water. So we will, I'll be talking a little bit about that, but the ins and outs of environmental and water law, I will not be covering tonight. I'm just going to talk about the impact of the treaty and the laws that we've got set into place. Here's a bit of a more descriptive picture of the Navajo Nation itself too, just again to give you an idea. This is a huge piece of territory, although honestly when it was originally negotiated, it's a very small piece of the original Navajo homeland, which is what they were negotiating in the treaty. So at the time that the treaty was signed, the most important thing, if you look to the history, and again, I won't spend too much time here on the history specifically, too much, but it does have an impact on the legalities here. And under this treaty, the Navajos wanted some of their original homeland, and that was really an important part in how they negotiated the treaty with the U.S. government. Now, at the time, of course, the land looked very different, and their access to water and hunting and various other things was very, very different. And so, originally they had been placed in a place where the land actually could not have crops grown on it. There was a problem with the land, but instead of being able to move as they normally would have been, there were problems. And so this piece of land kind of was set out specifically for the Navajo Nation based off of wanting to have a part of their original homeland as their original reservation. So a deeper investigation in the 1628. I do have information on that. I probably won't go into that tonight because it's not a key piece to the case, but it absolutely is an essential piece to the history behind all of this. What I want to start with, though, is really the treaty that starts all of this out. And this treaty was signed in 1868, and it sets out multiple articles where the Navajos and the government agreed on terms. As we all know, we had a very tumultuous relationship going on, and so there were a lot of important parts established. This treaty is the entire reason why these cases have all gone up to the U.S. Supreme Court. So I think we have to really look at this treaty to begin our discussion on this case to see what was agreed to. One side is arguing this is essentially a contract. Another side is arguing there is a guardianship or a fiduciary duty of the United States government that was set out here. So the U.S. government said, we'll protect you, we will guard the situation. And the other side is saying, well, we still have a right when we sign this to have some protections. So I think it's important to kind of go through some of the parts involved in the treaty. So let me walk you through that first, and then we'll start digging into the case and some of the precedent that was set out prior to the case. So first, we've got the Treaty with the Navajo of 1868, articles of a treaty and agreement made and entered into at Fort Sumner, New Mexico, on the first day of June, 1868, by and between the United States, represented by its commissioners, Lieutenant General W.T. Sherman, and Colonel Samuel F. Tappan of the one part, and the Navajo Nation or the tribe of Indians, represented by their chiefs and headmen, duly authorized and empowered to act for the whole people of said nation or tribe. So here we go. Then we get into the pieces of it. And that's a great question. What can non-Indigenous people do to help? I think probably one of the biggest issues is awareness. I think the more of a spotlight that can be shown onto issues like this, the more help or the more resources can be made available. So I think just knowing and understanding the history can be extremely helpful. But we've got Article 1 here, which is setting out peace and friendship between the government and the Indians. So they're pledging now on their honor for peace. That's set out in Article 1. Now I won't be reading through every. There's little summaries here in the corner. So this paragraph goes into offenders among the whites to be arrested and punished. So we've got some jurisdictional questions here. Among the Indians to be given up to the United States. So, and again, this language is the language of the time here. So we've got terms like the bad men and colors as types of people rather than anything more than that. This was 1868. So here, offenders among the whites, among the Indians who will be given to the United States. Here are some rules set out ascertaining damages. So the president may prescribe such rules and regulations for ascertaining damages. This becomes important because of the separation of power issues that go on. Article 2 goes into reservation boundaries. So here they're very specific about where the boundaries are, not just using the terms for map making, but also the local terms as well. So we've got the different landmarks that set out the reservation itself. Next, who not to reside thereon is specified here. And again, we've got may be authorized to enter upon Indian reservations and discharge of duties, but overall, who's got jurisdiction of that reservation? Then we bump down to Article 3, buildings to be erected by the United States. So some buildings at some point without said reservation where timber and water may be convenient. The following buildings: a warehouse to cost not excluding $2,500, an agency building for the residence of the agent not to cost more than $3,000, a carpenter shop, a blacksmith shop not to cost exceeding $1,000 each, and a schoolhouse and a chapel, so soon as sufficient number of children can be induced to attend school, which shall not cost to exceed $5,000. And the reason I point this out is because one of the biggest questions that comes out is, in this treaty, were water rights specified? And the argument is no, they weren't specifically set out in the treaty, but they were implied. And this is one of the few places where water is mentioned. So that's why I pull your attention to Article 3. Article 4, an agent to make his home and reside wherein. So we've got an agent of the United States here. And that takes us to Article 5. And this is the Treaty of 1868. Heads of the family desiring to commence farming may select lands, etc. Effect of such selection, so how to go about having the farming lands. Persons not heads of the families. Certificates of selection to be delivered, to be recorded, a survey, alienation and descent of property. So this goes into the farmland questions. Now we go on here to Article 6, children between 6 and 16 to attend school. And this was an issue across the United States, not just here, but this was something that was important here for the United States. The United States agrees that for every 30 children between said ages who can be induced or compelled to attend school, a house shall be provided and a teacher competent to teach the elementary branches of an English education shall be furnished, who will reside among said Indians and faithfully discharge his or her duties as a teacher. So this was another critical part of that treaty. And then we get into Article 7. Seeds and agricultural implements. So this is where they're saying the government will give some seeds and some different pieces. Now, what's interesting here about Article 7 is this is actually brought up by the U.S. Supreme Court through questioning during the oral arguments of the Navajo case in front of them, claiming that giving seeds is a duty, but water rights were not a duty. So distinguishing that fiduciary duty issue. So just pointing that out for later reference. Now, Article 8, delivery of articles in lieu of money and annuities, clothing, etc. Indians to be furnished with no articles they can make. So again, this goes into more specifics about what the Indians are allowed to have and not to have at the time the treaty was made. Hold on here. Please forgive me for 1 second. There we go. Now that takes us then, hopefully everyone can still see okay, let me know. Make sure I'm getting you focused. There we go. Over here, so annual appropriation in money for 10 years. So 10 years of assistance was granted. Changes as well, an Army officer to attend delivery of goods. That again was set out for protection purposes. Stipulations by the Indians as to outside territory. So Article 9 goes into some of the agreements that the Indians had given to the government. In consideration of the advantages and benefits conferred by this treaty and the many pledges of friendship by the United States, the tribes who were parties to this agreement hereby stipulate that they will relinquish all right to occupy any territory outside their reservation, as herein defined, but retain the right to hunt on any unaccompanied lands contiguous to their reservation, so long as the large game may range thereon in such numbers as to justify the chase, and they, the said Indians, further expressly agree. I'd like to pause for a minute, and if you think about the timing of this treaty and the amount of animals that were available for hunting and large game in particular, that's pretty significantly changed as of today's date. So some of the pieces of this treaty have a bit of this issue of what's happened because of the significant changes in the landscape from the time that this treaty was signed. So further agreements. First, they will make no opposition to the construction of railroads now being built or hereafter to be built across the continent. 2, they will not interfere with the peaceful construction of any railroad not passing over their reservation as herein defined. 3, that they will not attack any persons at home or traveling, nor molest or disturb any wagon trains, coaches, mules, or cattle belonging to the people of the United States or to the persons friendly therein. 4th, that they will never capture or carry off from the settlements women or children. 5th, they will never kill or scalp white men, nor attempt to do them harm. 6th, they will not in future oppose the construction of railroad, wagon roads, mail stations, or other works of utility or necessity which may be ordered or permitted by the laws of the United States. And that goes on further to explain more of that agreement. And then 7th, they will make no opposition to the military posts or roads now established or that may be established not in violation of treaties heretofore made or hereafter to be made with any of the Indian tribes. So these were the agreed upon pieces. Right, that is quite a question as to whether or not the government would comply with these treaties. And that has been an ongoing question. And again, at the very heart of the case that was handed down just a couple weeks ago. So Article 10 goes into the cession of the reservation not to be valid unless, so no future treaties can kind of hop over this one. Article 11, Indians to go to reservation when required. They're hereby agree that at any time after the signing of these presents, they will proceed in such manner as to be required of them by the agent. So this is them forcing them to go then into the reservations at this point, and they agreed upon it. Perhaps force isn't the right word, but required. Article 12 goes into appropriations and how they're to be dispersed. So we've got some money involved here. We've got removal, sheep and goats, cattle and corn, what happens to the remainder amount and removal here. And I think this one's really important also to note for the case that we'll go over here in just a minute. The removal of this tribe to be made under the supreme control and direction of the military commander of the territory of New Mexico, and when completed, the management of the tribe to revert to the proper agent. So that, again, is the removal provision. So Article 13 here reservation to be a permanent home of Indians. Now, this is another essential piece that gets debated in this case that was just a couple weeks ago in the U.S. Supreme Court. What does it mean for a place to be a permanent home? Is it just the land, or is it what's above and what's below the land? And then if it's all of those things, then is water included in that? Because water is something that's movable, it changes, unlike something like timber that is kind of in its place until it's chopped down and replanted. But water is kind of its own creature, and this really becomes a huge question of, we have this agreement to make this land inhabitable or a permanent home for the Indians, and does that mean then water rights should be reserved to the Indians? Later on through case law, we'll find out, yes, there are some water rights, but the extent is continuously being debated. And last, we've got the penalty for leaving the reservation as well. So Article 13 really encompasses a lot of that. And that takes us to the end of the treaty. So that's kind of the overview of the agreement, the contract, if you will, that set out the boundaries for the land for the Navajo Nation. And the agreement that they had to go into this reservation that was being created by the U.S. government. And just as a reminder, again, here is where the Navajo Nation is located, and they are within. We've got Colorado, New Mexico, Arizona. California is here because the Colorado River kind of goes through there, Utah, and then Nevada as well. So we've got multiple states surrounding the Navajo Nation. So there are a lot of different interests set out here. So when we actually look to this case now, we're going to talk specifically. We've got this 1868 peace treaty that was signed. Everybody knew what was what at the time, such that it was. And again, one of the most pivotal pieces for the Navajo Nation was they wanted part of their original homeland back. And of course, this was just a small piece, but the location was very important to them. At the time, the water that was available to them was sufficient. They would be able to go and gather water as well with the technology that was available at the time. So you can see here, again, the water that was available. So those kinds of things were not put into the treaty. Now the argument is, if the United States had wanted the Navajos to have water rights, they would have specified it in the treaty, and it was not specified. It just said a livable area of land. But the implication is, in order for it to be livable, you have to have water. That's necessary to make it livable. So that takes us then into the case itself. And for Arizona v. Navajo Nation, this is a case where the Navajo Nation is requesting that the United States survey the situation and determine what water rights that the Navajo Nation has. That's what they're asking. Their case was dismissed at the lowest court. They said there's no jurisdiction, it's not appropriate here. It was appealed. Then the circuit court said, yes, I think this is a valid question. It was appealed again to the U.S. Supreme Court. And in this case, they're arguing about whether or not the United States has an affirmative duty to provide some kind of surveillance of what the Navajo Nation's water rights are. That's all they're asking for. This is not an action for damages. This is not an action for reparations. This is an action asking the United States to conduct a survey of what water rights are available to the Navajo Nation. And that's really what is one of the things that makes this so interesting, is that they are just asking for the determination of water rights. Now, they weren't asking here for infrastructure. They weren't asking for only one kind of water to be assessed in a particular place. They were just asking the United States to go in and assess the Navajo water rights. Now, the other issue that really comes up here that makes everything really complicated is that the United States acts in like a fiduciary role, or that's a question, but or guardianship role of the Indian water rights, and that's been set out in different case laws. So let me take you through some of the most important cases as background information to just give you a little bit, some stepping stones before we really jump off into this case. One of the most important cases, of course, that came out of the U.S. Supreme Court, which I just posted on, and I'm not sure if it's actually gone up yet or not, but right. Well, as the bottom denominator, it's American water rights. It's a good question. I mean, who is an American? I think, and that's been asked by the judges and in the case law over the years, because we've got such a huge question here of whose priorities should be put into place. And big argument, of course, is that the treaty sets out priorities because a treaty, this agreement between the Native peoples and the U.S. government kind of set out, hey, we've got priorities here. This is, you told us, you gave us these rights because of the treaty we all agreed upon. And so that's a great question. That really is the question. One of them. So the first case that really is such a pivotal case, and I cannot emphasize this enough, is the Winters case. The Winters case was decided in 1908. Now, this case is really old, but I think it really shows how incredibly important some of these cases are historically, because this case was cited over and over and over again in a case that was just decided a couple weeks ago. In the Winters case, what we have is a group of Native Americans, a group of different tribes, and they put together a reservation agreement in May 1st of 1888, and it was called the Fort Belknap Reservation. Okay, I'm not going to go into every single line here, but there was an agreement amongst the United States government and these different groups of tribes for this piece of land. Now, once this piece of land, which was later in an area called Montana, this was set out in 1888. Now, what happened was in 1889, Montana became a part of the United States. And with that, a whole bunch of settlers came into the area. And when they came into the area, they blocked water, they built dams, they put a lot of different kinds of infrastructure into place that took water away from the reservation so that the settlers could have this water and use this water. So the reservation, which was represented by the United States because of a couple of interesting things on why they're representing the United States, but they came in and they sued these settlers, and they said, you cannot use this water this way because you are keeping it from the Native peoples on this reservation. We have a treaty in place, we have an agreement, and within that agreement is that it's to be a livable place for the Native indigenous people here. Now, the settlers were like, we've got this act that Congress just passed. It made it made Montana part of the Union, and so now we get to do whatever we want. And so too bad. They went up to the U.S. Supreme Court, and surprisingly, and that's why this case is so unique, is that the court actually held for the Native American tribes. And in this case, they said, and in fact, they were a bit aggressive in their language, and they said, look, we've got this act passed by Congress 1 year later, and just because this act was passed doesn't mean you get to supersede our treaties. And so the treaties that we had made with the Native peoples establishing this reservation, the Fort Belknap Reservation, the treaty is legit. And within that is this inferred right of water rights, because you have to have water in order to live. So you may not come in as settlers and deprive the indigenous people of their water, because within the treaty is that inference that in order for the place to be livable, you need to have water. So this case established this idea that treaties do not have to explicitly set out water rights for Native reservations. They don't have to say it. You don't have to specifically write it, but that it's there anyway within the implication of a livable place. It's not just a tract of land. Now, the Winters case is used constantly when dealing with water rights in our Native American tribes or any of our indigenous tribes. This is the case here. This is a citation. It's interesting. It's a fascinating case because it kicked off what we now call the Winters Doctrine, which is a whole set of cases that just kind of are trying to define this even further. So what exactly does it mean, this implied rights of water? Does that mean we have to set up wells? Does that mean we have to set up a way to irrigate farms? Or is it just regular water that's needed in order to survive? What about plants? What about farm animals? What about bringing it from another source that's way, way far away and bringing it to the reservation? Do we have to do that? So what exactly is needed or meant by water rights reserved to the Native peoples? And that's a question that was asked over and over and over again in a ton of cases. So in this case, in the Arizona v. Navajo case, that question came up again, and it's the very first case cited within the decision that was just given here on the 22nd of June, where they're going into what exactly these water rights mean. The federal government's reservation of land for an Indian tribe implicitly reserves the right to use needed water from various sources, such as groundwaters, rivers, streams, lakes, and springs that arise on, border, cross, underlie, or are encompassed within the reservation. And that's a direct quote from the Winters case. So you would think that this would kind of be an open and shut case where the Navajo Nation is saying, hey, government, can you assess our water rights? We're having a huge water crisis on our reservation. The amount of water that's readily available is not livable. And so we need to have an assessment done. Now, what happens after that? We don't know. An agreement is typically made about how to go about taking care of the water issues, but we're just asking for the assessment to be made is what the Navajo Nation is requesting. So other cases that come in to play, because the justices are asking, first of all, do we have a breach of trust claim? And they're citing a previous case. So was this treaty or were these water rights essentially a breach of trust? And that takes us into trust law. And when there's trust law, we have a different set of requirements. If there's a breach of trust, so it's a breach of contract, it's kind of an automatic, and then it's pretty easy. Was there a duty? Did you breach that duty? Yes. Okay, let's go forward and take care of it. So they cited the Hickoria case. This is an Apache Nation case. And they said in this Apache case, the fact pattern was very different. This had to do with them suing, the Apache Nation was suing the government, saying that they were not giving enough resources to the Apache Nation. So because of that, they said there was a breach of duty. So like in any trust, if the person who's in charge of the trust isn't giving out the money to the person that's supposed to have it, you can sue, and that's what they did. Here they did a motion to compel documents because they wanted documents from the government going into where the proceeds went to, because they didn't go to the tribe, they went somewhere else. The motion to compel the documents went up in front of multiple courts because the defendant here, the U.S. government, said, we've got attorney-client privilege, so any documents with attorney-client privilege we're not going to give over, even if it shows what's the problem is here, that we breached a fiduciary duty. So the tribes came in and said there's a fiduciary exception. So when a fiduciary relationship exists, there's an exception to that attorney-client privilege. So give us the documents. Again, all the way back up to the U.S. Supreme Court over and over and over again. And they're arguing what are the fiduciary boundaries when it comes to Native American tribes, to Indian tribes. Now this court, and keep in mind this case really wasn't that long ago. Legally, this case was just yesterday. It was 2011, and it was written by Justice Alito. And the holding in this case says the fiduciary exception to the attorney-client privilege does not apply to the general trust relationship between the United States and the Indian tribes. So the court specified a particular exception when it comes to Indian tribes. So fiduciary duties and that exception in any other situation, absolutely it counts, but not in cases of Indian tribes. Only Indian tribes. They are an exception. They are not covered, so they cannot benefit. Alito goes into some other cases that he cites saying, they're not supposed to have this level of fiduciary duty, and then they are. I mean, it goes back and forth. What is very interesting in the justification set out in this case, saying that Native Americans are not covered because the fiduciary relationship is not the same, and they're the only exception out of all fiduciary relationships. What's interesting is that you will see a perfect example of when the court makes a decision, how much law they can find to support their decision. So if Alito wanted to come in and say, nope, you guys can't have the benefits of this exception, he's got case law. But if you go and you read the dissent has case law saying, yes, they should be qualified under this exception. So it all depends on who is in charge in the court. The U.S. Supreme Court drew that line. And in this case, in the Hickory case, they said no protections are going to be allotted to you because this particular relationship is not qualified. And again, I just cannot emphasize the importance of how this one group of people is singled out as not being protected by a piece of law that protects every other group of people. So that's the Hickory case. Now, there was a big question as to whether or not that case really even applied, but we're going back again into Arizona v. Navajo. I'm going to kind of pop in and out of this case, but the first justification for the holding here, the treaty establishing the Navajo Reservation reserved necessary water to accomplish the purpose of the Navajo Reservation, but did not require the United States to take affirmative steps to secure water for the tribe. That's the key holding in the Navajo Nation case that just came down. And they said, yes, of course, there's necessary water that's needed, but we don't, as the United States, have any kind of obligation to assist with that in any manner. And even if assisting meant doing a survey of what water rights the Navajo Nation has, there's no duty that the United States has to do that. So there's no obligation. Justification, part A here, they're going into the tribe saying there's a breach of trust claim. And the court is citing its own case, the Hickory case that I just talked about, saying the government owes no judicially enforceable duties to the tribe. So they're supporting, again, this case, this decision, with a case where they held that Native American exception just because of who they are. That takes us down into then more cases cited. We've got several more cases that the justice is citing here, and this is Justice Kavanaugh writing this decision, where he is claiming that there is other case law that's setting apart reservations for use and occupation of the Navajo tribe. So this is a prior case that was just set out, the Navajo Nation case, and then he cites the Choctaw case. Now, I find this absolutely fascinating as an attorney that he would cite this particular case, which is horrible, and I'm not even sure I will be able to put it up on the live. Let me see if I have redacted enough of the language. This case is so offensive. It's just, it was a case that was decided. Here we go. I just put the first page here out. I'm not going to be able to show this case because the language is so offensive that it's just, I don't think appropriate for me to put up here. But here's the case. It's the Choctaw Nation, and it was decided March 8th of 1943. And this case goes into more of how we're supposed to be looking to the language of the treaty to make a determination of what was meant at the time. So this case, which of course you can go and pull this case up. It's online and you can take a look at it and read through it. And the court is basically pulling apart how different tribes interpreted the treaties and different requirements that were given to them. So he's citing this case, which yet again is a horribly offensive case all the way around. So Indian treaties cannot be rewritten or expanded beyond their clear terms. Meanwhile, those clear terms are a huge question in that case, but there you have it. He cited that case. To be sure, this court's precedents have stated that the United States maintains a general trust relationship with Indian tribes, including the Navajos. And again, he's going into that Jicarilla case, which has to do with the fact that Indians are not covered by the fiduciary exception, unlike anyone else. Now, I will try my hardest to not be biased, but this case is a little bit frustrating to read, because I think as a lawyer, when you see a judge or a couple of justices twisting the law into a way that makes sense for their end goal, it's frustrating. That's not how the law is supposed to work. And it's a classic example of this term of weaponizing the law and using it in a way to suit what the judge wants to have as the decision. So this is a bit of a frustrating case, although with some legitimate points on both sides. Frustrating for me overall. Now we go further down. So these are the cases that I've already pulled for you. We've already talked about these cases. Next, we go into Justice Kavanaugh's second piece. Other arguments offered by the Navajo tribe to support its claim under the 1868 treaty are unpersuasive. Now, as a side note, when this was argued in front of the U.S. Supreme Court, keep in mind that it's the government in its representation of the Navajo Nation's capacity here. So we've got kind of an interesting intersection of rights where the Navajo tribe is saying, we would like to have a say in this. Meanwhile, the government is saying, we actually represent you. So, step to the side. So first, that the 1868 treaty established the Navajo reservation as a permanent home does not mean that the United States agreed to take affirmative steps to secure water for the tribe. So that's an essential holding to the case. So just because it's a permanent home doesn't mean securing water rights is part of that permanent home. And that's pretty important. And especially in this case where they're just asking for a surveillance of water rights. They're not asking for implementation. Second, the treaty's express requirement that the United States supply seeds and agricultural implements. Remember that part of the treaty where I was talking about how the government said, sure, we'll give you some seeds in 1868. So here, in a decision just a couple weeks ago, the treaty's express requirement the United States supply seeds and agricultural implements for a 3-year period to the tribe does not, as the tribe contends, mean that the United States has an additional duty to make affirmative steps to secure water, but rather demonstrates that the United States and the Navajos knew how to impose specific affirmative duties on the United States under the treaty. So it's offensive is what it is. Because what they're saying is, hey, you wrote in your treaty that the states have to give you seeds in 1868. And so that doesn't mean that we have any affirmative duties, because if you had wanted an affirmative duty, you would have set it out in that treaty of 1868, which is in complete and total contradiction then with the Winters case. The Winters case specifically says if you don't have water rights written into your treaty, they can be inferred. They are implied in your treaty. Now, this case is saying if they wanted them to be affirmed, they would have written it in there because they said they were going to give them seeds. So why wouldn't they write in water rights? This kind of sets aside this issue of at the time when the land was being negotiated for, that water rights or the access to water was such an innate part of the land that it didn't bear mentioning actually within the treaty. And that's one of the biggest arguments, was who could have thought that giving land without water would have even been an idea that would have crossed anyone's mind. But Justice Kavanaugh disagrees. Third, the tribe asserts that the United States' purported control over the reserved water rights supports the view that the United States owes trust duties to the Navajo, but the federal government's liability on a breach of trust claim cannot be premised on control alone. Now, this is specifically going to a particular area that I think a lot of people have questions, which is, can you sue the federal government for breach of trust? Now that, yes, first in time, first in line. Now, that's controversial only because it seems like the water rights issues set out in the East versus the West are very different. And this first in time, first in line means something different depending on where you are in the United States. A very important assessment to be made when it comes to water rights, absolutely. But what it actually means depends on where you're at. So when we go to Justice Kavanaugh's last piece here, when he's saying that we've got a federal government liability, he's referring to Title 26 of the Judiciary and Judicial Procedure Act. I'm not going to spend a lot of time on this either because it's pretty dry. But if you are ever wondering if you could sue the United States, it's going to be under Section 1346, United States as Defendant. This was set out as a way through an Administrative Procedure Act, to be able to sue the United States when there is a breach of duty. It sets out which courts would have jurisdiction and how to go about it. So this is what he is referring to when he's saying we have this federal government's liability on a breach of trust claim. It cannot be premised on control alone, and what they're saying is not just control under the statute. There's something else that is required, that's needed in order to go forward in a lawsuit. So this gets through that sovereign immunity kind of issue that we have when it comes to suing the government. And he's saying, you didn't give us enough. You do not have enough information here or a specific enough law to cite that gives you the ability to sue the United States. Now, one of the questions was, what about the Tucker Act? And again, I won't spend too much time on this, but this is an act set out in 1887 where the United States waives its sovereign immunity. Questions involved in that. If you go and listen to the oral arguments on this case, on Arizona v. Navajo, you will hear Justice Ketanji Jackson Brown really hammer home the idea that the Tucker Act really isn't at play in this situation. But somehow Justice Kavanaugh is able to twist this around so that it makes sense for their final decision. Finally, the text and Treaty of the Records and the treaty negotiations do not support the claim that in 1868 the Navajos would have understood the treaty to mean that the United States must take affirmative steps to secure water for the tribe. So this last piece, he's saying, if you look to the treaty and the records of the negotiations, the Navajos would not have expected to have any kind of affirmative steps or assistance securing the water rights. Now, how he came to that conclusion, I do not know. And even reading through the entire case and reading through all of his rationale, it's very difficult to figure out how this has been turned in that direction when you actually look at the language, just the language of the treaty itself, because it's important. And Justice Kavanaugh says, hey, let's look to the plain language in the treaty. Like, okay, I did that, but what you have held here does not make sense. So he is saying the Navajos at the time would not have expected the United States to make affirmative steps. Several things that point to the other side of that would be, under this treaty, this expectation of protection and guardianship. How throughout this entire treaty, they're talking about having military on the reservation. They're talking about having teachers. They're talking about having government agents. All of these are put into place under the guise of protecting this reservation. Now, those affirmative pieces, then, he is saying that that kind of protection would not have covered the necessity of water. So that is a bit of a stretch, I think, in his analysis. So, yes, there are, the water rights are different, and they're really different, too. They're not just a little bit, they're quite a bit. But this last piece, I would say, is probably one of the I don't know, I guess legally it doesn't make a lot of sense, but it's also just offensive to decide that based off of this treaty that the Navajos would not have assumed that the water would have been involved. But there you have it. That would be Justice Kavanaugh's decision. Now we've got Kavanaugh, who wrote the opinion for the court, Chief Justice Roberts, who agreed with that. He had a lot of questions about fiduciary duty and those kinds of things during oral argument. Justice Thomas really went on. He wrote his own concurring opinion for this case, and he really went into this idea of a breach of trust claim, where basically there should be no circumstances in which an Indian tribe would have a breach of trust because of how the law is written. That's his perspective in a concurring opinion. Justice Alito continued to ask the question repeatedly about per capita, how many Indian or Navajos, how much water did they need versus how much water the rest of the people in Arizona needed. So what was the per capita usage? Now, one of the attorneys argued and said, per capita, they use about 80 gallons a day. Meanwhile, the Navajo are looking at more around 7. And that number was not something that he was interested in hearing. Justice Alito kind of admonished the attorney for not having those numbers, although those numbers are listed in several of the amicus briefs. Again, this idea of measuring this out at a per capita kind of measurement would be, again, it's a bit offensive that's how we're looking at water here rather than the necessity of life. Now, also Chief Justice Roberts also went into quite a bit of question about other sources of water, groundwater, other rivers that were available, other waters that were available. And the argument against that was simply, we're not here to say that we only want water from one place. What we're asking the government to do is assess what water rights we have, not to just talk about the Colorado River, the top or the bottom. We're talking about all of it. So, yeah, it's a bit frustrating, especially this idea with Justice Alito going into trying to quantify how much water is allowed for the reservation versus the rest of the people in Arizona. Several of the amicus briefs also went into this idea that if they were to say to the government that they needed to do a water rights assessment, that it would be a slippery slope, and that a whole bunch of other Indian tribes would then be requesting from the government water rights assessments. And that would be impermissible. It shouldn't be allowed that the government should make those kinds of assessments for different Indian tribes. That was multiple arguments were placed on both sides of that within this, and Justice Alito really hammered that home. And it makes sense that would be Justice Alito's opinion, given the Jicarilla case that he wrote as well. So I think he really held pretty firm onto his innate opinion of that situation. So, again, I'm trying to not be too biased, but it's a bit difficult with the history here. It's just a bit difficult when things are so blatantly, so clearly discriminatory. It's just so clear. I mean, there's really not much for questions on either side. But apparently Justice Kavanaugh felt there were, as did Alito. Now, Justice Barrett had some excellent questions for everybody during oral arguments. Excellent questions. Asking about this fiduciary duty issue. She made some very, very good points. And she did vote with the majority here, but made some very good points. Now, you'll note the dissenting opinion here has Justice Gorsuch writing for those that disagreed. We've got Sotomayor, Kagan, and Justice Jackson all dissented in this case, but Justice Gorsuch was the one that wrote the dissenting opinion. And if you go to the dissenting opinion, which again, the majority opinion is what is cited law, the dissenting opinion goes into why the justices dissented. And if you read his dissent, what you'll find is, I mean, it's hot. It's like, whew, he's hot. He's angry. He's got some anger about how the majority court held in this case. And repeatedly during his questions to counsel during oral arguments, along with his rationale throughout his dissent, he was very clear. There is no way for the Navajo Nation to seek any kind of accountability or remedy from the U.S. government because of how these cases continue to go down, as well as how the judges are interpreting the law. So he has some very interesting points here. The court rejects a request the Navajo Nation never made. And I think that's a key piece here. This case is not about compelling the federal government to take affirmative steps to secure water for the Navajos. Respectfully, the relief the tribe seeks is far more modest. And he will go into further that what they're requesting is that an assessment of water rights be made. Not implemented, none of that, but just the assessment. They want the United States to identify the water rights it holds for them. And that's the other issue, is that they're holding it in trust, essentially, which is debatable, for the Indian tribes. Because there is nothing remarkable about any of this, I would affirm the Ninth Circuit's judgment and allow the Navajos case to proceed. And again, this shows just the fact that the decision of this case tossed out the ability for the Navajo Nation to go forward on this issue and argue it. So this, and if you've read much from Justice Gorsuch, you will see that he does like to kind of wax poetic, but he has some excellent points, and also has another way, which I find absolutely fascinating again, of interpreting the exact same cases that the majority court is citing. And so as he goes through the cases they're citing, he's saying that's just not how those cases were meant to be applied. So it is a fundamental difference, this absolute fundamental difference between those two sides. So that is really the overview then of Arizona v. the Navajo Nation and the water rights questions that had been presented in front of the U.S. Supreme Court just a couple weeks ago is when that opinion came down. So that's kind of my overview. There are a lot of other cases involved that I didn't spend much time on tonight because, again, I really wanted to kind of get into the heart of this case. But if you really want to know more about the water rights when it comes to Indian reservations, you can't look at it without going through the Arizona cases. I'm just showing them to you here. The first, we've got a set of three, really two, and they're referred to as Arizona 1 and Arizona 2. And this is Arizona v. California. This was decided in 1963, and it has to do with the water rights, again, in the Native American tribes. This was an essential case, absolutely important in defining whose rights are set out where. As an interesting side note, you'll note here that the Navajo Nation was not part of this particular argument, even within the Arizona v. California case that came out in 1983. The government representing the tribes did not allow for the Navajo Nation to come in when it came to these cases. So, and this is the Arizona v. California case in 2000. And this case was decided by Justice Ginsburg, and the decision in this case, again, was over these first two cases, and she basically said, let them take it to court and decide it at court. So, the three Arizona cases, we have the Arizona 1963 case, we have basically an amendment to the Arizona case in 1983, and then the last one was in 2000 by Justice Ginsburg. So that is the the Arizona-California trilogy cases that also set out in great detail this idea of water rights when it comes to Indian reservations. So hopefully that was informative for everyone. I hope that kind of gives you an overall view of how these cases were decided. The Solicitor General duties for filing the docket. Well, let me see. take a look. Right. So it looks like, I mean, it's not, there's not a lot really to go into other than the Solicitor General is basically the same as an Attorney General for the state. So any of the cases where the government's involved, the Solicitor General will take a look at those cases and make sure everything is set the way it should be and if there's a valid case to go forward or not. So that's kind of it. Should pre-LaGuardia be scrutinized because creative and affirmative action? Oh, that I don't know. That I have no idea about. But I would need more information on that particular case, but I don't think so. I don't think, the attorney generals of our states, as well as the Solicitor General, they fall in line with what the law is for whatever position that they have. So the attorneys in these cases, they take their cases, their arguments the best that they can in front of the U.S. Supreme Court. They give it the best job that they can with what they've got to work with. And sometimes you win and sometimes you lose. And that's kind of the nature of how adversarial our system is. And a lot of times, too, with these cases, I mean, make no mistake, these U.S. Supreme Court cases are decided by the justices. So this decision was made by Justice Kavanaugh, and the Hickory case, that was made by Justice Alito. So these cases, any of these cases that are frustrating or that you feel, once you've read them and gotten all the facts, you feel were cited incorrectly, that is because of the judges who decided the cases. Now, how do we decide on our judges? It has to do with who is elected as president and who is elected to the Senate. So all of this comes down to who you vote for. So voting is the key. If the cases in the Supreme Court are not in line with how you feel, or they are, that has to do with who you vote for and who you elect into office. Yes, they do. She basically filters what gets on the docket, and to some degree, but it's ultimately up to the U.S. Supreme Court who gets granted cert and what they want their docket to look like. So she's got some power, but not definitive power for sure. Is bought and paid for. Justice and human rights will never be given to us. It's a valid question, and it's a question that we've had since the creation of the U.S. Supreme Court. And we had so many problems with the U.S. Supreme Court before Justice Marshall came in and said, this is how we're going to design the U.S. Supreme Court. We had all kinds of stuff going on. We had President Jackson, who was like, forget about it. I'm not going to enforce this particular case that the Supreme Court had. We had another time where they passed the 11th Amendment because everyone's like, I cannot believe the U.S. Supreme Court just handed down that case. We can't have that happen again. So they passed the 11th Amendment. Multiple amendments have been passed since then in order to kind of circumvent or to correct mistakes the U.S. Supreme Court has made. I don't think people have a real idea of how incredibly powerful the U.S. Supreme Court is until it switches like this. And I wouldn't say that this is a landmark or, huge moment in history with this Supreme Court. No, I think it's always been this way. And you can look back to all the courts we've had in the past where we've had Chief Justice Warren, who was said that Eisenhower called him his greatest mistake by appointing him Chief Justice. And we have the Three Musketeers versus the Four Horsemen of the Apocalypse, which sets out different justices on different cases out of the 30s and 40s. We've got the Lochner era case. We've got the Plessy v. Ferguson era Supreme Court. I mean, there have been, since the beginning, there are issues where it goes back and forth on one side to the other. Although it tends to swing a bit like a pendulum, but until people really, really get and understand that it's all about who you elect, I don't think much will be changed about it. The infrastructure itself is solid, and whether or not they should have lifetime appointments, you can ask that of all the states. Some of the states have lifetime appointments. Other states, you have to go in every few years and re-elect your Supreme Court justices. So you can look to those different kinds of states and see how their court systems are, and if that seems like it's a good idea or not. So if that way of having judges is the best way, we would have to rewrite the U.S. Constitution. And at this point, I'm not sure we can get anyone to agree on much of anything, much less rewriting Article 3 of the Constitution. I just can't see that, but very dubious and contrived, so why weren't they denied? And you ask a valid question. 303 and AA, I think, and what I have been trying to put out there is those are not exceptions or blips on the radar. They are part of what has been trending in the U.S. Supreme Court. It is not a surprise. This case itself was decided within the same parameters of both of those cases. Those cases have gotten a lot of press, but if you look at all of the other cases that have been coming out of the U.S. Supreme Court over the last couple of years, you will see that it is trending a certain way. And those cases are reflective of that trend. Can you post on your website the decisions made over time by SCOTUS? I can. I do try to post some of the historical cases, and I have started a series on some of the worst cases or worst U.S. Supreme Court justices in the history of the U.S. Supreme Court. But it's not a particularly positive look. But we've got a lot. We have a lot of U.S. Supreme Court justices that were just atrocious, just awful. I mean, and this is well known within the legal world. Some of these justices, you may come across an opinion here and there. As an attorney, we'll read it and we're like, oh my gosh, I cannot believe this guy was on the bench for so long. But, that's, again, the nature of the beast. It's been a problem since the beginning, but I absolutely can do that. Oh, absolutely. And I do try to put a lot of those cases, post them up on my account. You'll have to kind of search them, and you probably don't know which cases to look for. So what I will probably do is post a video specifically outlining the best cases to search. And then that way you can just put them into the search in TikTok and you can pull up those videos. We've got the habeas corpus case with Abraham Lincoln versus the U.S. Supreme Court. That was a big one. We've got the Georgia case. That was another big one. The Andrew Jackson case. That was also another big one. Lochner, Plessy, all of those cases I've posted on. So, but you probably just would have no idea what to look for. So I will put together a post just talking about the cases, the most important cases. I'll put that together and try to have that posted in the next couple of days so you can take a look. But it is interesting if you look over the years. Very, very interesting how things have gone back and forth and back and forth. And, we still have Buck v. Bell on the books where forced sterilization was allowed. Meanwhile, for men, forced sterilization was deemed unconstitutional. So these are all still on the books. Good law that's been decided. Once you start peeling the pieces or the layers away, you'll start to see underneath that all of this has been in place for years and years and years. Yeah, give them seeds and no water. I know, right? Oh, what kind of stone is this? This is a mood ring. I got it at a wonderful little shop on a reservation, actually. So it's kind of my tip of my hat. But yes, thanks for asking about that. Yeah, and give them seeds and no water. And that was actually debated during oral arguments. This ridiculous notion that, well, we gave them seeds in 1868, so that was enough. We finished our duty. That was enough. Oh, yes. Oh, Diane, my goodness, the racism. My gosh, if you want some of the most horrendous cases that you can actually hear oral arguments for, where you hear the Supreme Court justices using terms that we would never use ever these days. And these cases are absolutely heartbreaking, because of how they use this language and the way that they come down on the facts of the case. So I've got several cases that I could recommend to you that you can go onto oyez.com, which is oyez.com, and listen to the cases and listen to how they're argued. Probably one of, there's several that are just absolutely, they just will curl your hair. And it doesn't matter if you believe these days one way or the other. When you hear the justices use these words and the terms that they use and the reference to actual human beings, the way that they refer to them, it is absolutely humbling to think of how we even got to where we are today. So what I will probably do also for you, Diane, I tell you what, I will make a post on some of the best cases to pull up on Oyez to listen to. How's that? I can't think of all of them off the top of my head. I would say probably the I want to just make sure that this oral argument is available. You can probably start with the Loving v. Virginia case that was decided on interracial marriage in 1967. If you go to oyez.com, you can listen to the arguments in the Loving case, and you can hear the justices arguing for and against that situation. And it is just, it's a lot. It's just a lot. And again, I'm not trying to belittle any experience that anyone has, but there are just certain cases that when you listen to how the judges who are supposed to be neutral and impartial are arguing the cases, it becomes just a whole new world that you're going to be diving into. I'm trying to see if I can pull up the one I was just listening to. And you can also, the Craig v. Boren case, I just posted on the idea of between men and women in the equal rights, equal protection and that. And that's the Craig v. Boren, B-O-R-E-N case. That also was in front of the U.S. Supreme Court. So that talks more about gender discrimination. So that was a very important case. And you can again hear how the justices are falling on that one and what their thoughts were on equal levels of protection for women and men. So that is also very interesting if you want to take a look at that. But I will put together a video because I think once you listen to those oral arguments, it is fascinating to see kind of how people went down. Oh, well, thank you very much. Yes, I try to be as neutral as possible. I think that's the best way to learn. I don't want to make up anybody's mind for them. I just want to help to show them the tools so that they can go and make their own decisions and decide for themselves. And that's really my goal. My opinion that their rulings are politically motivated because you don't agree with it. No, I would say anytime I disagree with an opinion, I can disagree with it, as all humans can agree or disagree. But as far as anything being politically motivated, I think I have a different view of what politics are, and perhaps that's because my background is in political science. That was actually my area that I specialized in. So focusing on the politics is different than focusing on the law. And so I think looking at the law and how the laws have changed is not necessarily, you can't pull politics completely out of it, but it's reflective of politics. But I'm not sure I certainly don't feel the political motivation involved as much as I think a lot of other people probably do. I like to try to pretend that they don't pull politics in, but it's getting harder and harder to pretend that way when they specifically put it in their opinions. I mean, if you write it in your opinion, it's pretty hard to miss. So that's where I make my assessment. But yes, everybody needs water. And again, it's that basic necessity and the prioritizing of different levels of who gets the water first, depending on where you're located, depending on what treaties have been signed, as well as the history behind the treaties. And of course, we have such a difficult and troubling history legally, as well as just historically, with our Indian tribes and our reservations. There's just a very tumultuous history there that continues to struggle to be addressed. But I think that, and I'm not trying to, I think that's true for any country where there are native peoples and there are other peoples coming into that country. I think that issue is huge, particularly in the area I've studied, which has been with the Aborigines in Australia. So there are a lot of issues to be taken into consideration. That's a nice way to say it. Well, Bush v. Gore, I have tried so many times to do a post on that case, but I cannot figure out how to do it without having the political piece of it involved. So I chew on that case regularly to try to figure out how to make it neutral enough to post it. And I have yet to get there, but that is a very, very interesting case. And it turned the tides, and it didn't turn the tides right away when it was decided. It turned the tides later. It's very, very interesting case. One I continue to try to maneuver into a neutral post. It's almost impossible. I'm still working on it, though. I'm still working on it. How I can make Bush v. Gore not about politics. I'm doing my best. We'll see what happens with that. But yeah, that was definitely a change that we saw within the U.S. Supreme Court. Lots of questions posed after that. And lots of questions have brought up that case in front of the U.S. Supreme Court just within the last 10 years. And that case has been mentioned more in the last 10 years than since it was reviewed. So it's very interesting. What about the original promises? That's a good question. And, I think that's really what the case is all about and as Justice Kavanaugh put it at the very end, he said, the text of the treaty and the records of the treaty negotiations do not support the claim. So, there's this idea that every treaty is unique and should be looked at in a unique way. And that's the assessment he made here. So how far in time do you go back to see who actually is the first? That's a great question. That is an excellent question on how far you go back. Absolutely an excellent question. And one I do not have an answer to. I just do not. I tend to stop at the Mayflower Compact because I find if I go further back into the Magna Carta, it gets too messy. But for me, I make my assessments based off of the Mayflower Compact and forward from that point on. But yeah, it's very difficult. Bush v. Gore was entirely about politics. Politics began the court's current. Yes. I think a lot of people would agree with you on that one. Absolutely would agree with you on that. It did seem like it was a pivotal point where before this, the court had been very reluctant to get involved in any kind of a question such as the one raised in Bush v. Gore, like deciding an election, and decided in this case to, make that decision. And it has had long-reaching ramifications for sure. There was a need to maintain the appearance. Law is distinct from politics. Yes, and I think the harder they argued that, the worse it got because they were trying to put forward like, oh, we're not politically motivated here. We don't want to have anything to do with politics, but it so clearly did. And it's another case, I think, too, where the court was able to kind of twist around the precedent that they needed to kind of get to the answer that they were looking for. And whenever that happens, it's always a bit of a, cringe moment. Yes, very interesting. I'll have to look that up. 1663. What have I missed? You just popped into my... Oh, well, welcome. I've been going through the Arizona v. Navajo Nation case decided by the U.S. Supreme Court June 22nd of 2023. So we've been kind of talking about the role of the U.S. Supreme Court and those kinds of things. The one thing about Bush v. Gore is that you cannot say it's not a well-written piece. And it really was well-written for what it did. It was incredibly well-written. I thought the supreme law of the land, Supreme Court cannot abrogate a treaty. Well, and that's a big question. That's one of the questions that can be asked. And they did cite multiple times different pieces of the Constitution, especially for jurisdictional questions that got raised time and time again. Actually, it was in the Winters case here, this landmark case in 1907, where they were discussing the jurisdiction that the Supreme Court has. And they go into the different pieces of the Constitution. What exactly the supreme law of the land means is what the U.S. Supreme Court decides it means. And that's the key here. And that is what happened in the Marbury versus Madison case that established judicial review. They specifically said the Constitution is the supreme law of the land, and we, the U.S. Supreme Court, we decide what the Constitution says. Civilization only looks at recent history. Only going back 500 years is not accurate. Very true. Very true. And I think, in the United States, we're a bit unique because our country, in its current form, because of the way that it was created slightly, because we don't have necessarily the long history that you can look at in some of, for example, in the UK or in Europe, where they've got centuries and centuries and thousands of years, or Greek or Greece, Italy, or in Asia, China. The history, my goodness, we just don't have that here with the current form of our government, with this current form. And so I think our perspective on history in the States is a bit different than that from around the world, where, you have the Vikings and you have so much history in Asia. My goodness. Just thousands of years of history, and in Africa too, and Northern Africa especially. Oh my goodness, we just don't have that perspective here, and I think it shows. I think that shows, and I'm not saying that's good or bad. I'm just saying, I think that's kind of part of the landscape we have here. Oh, thank you. Oh my goodness. Oh, look at that confetti. Oh, thank you. Right. It's very hard. Oh, happy birthday. Oh, thank you. Thanks very much. We truly do not know. Yes. And that's, that's, of course, that's a very good point. And even, amongst the tribes, there have been a lot of disagreements between the ownership of the lands and even the tribes before the most current set as well. So that history goes way back as well. So there are a lot of questions regarding land ownership. And I think, in the U.S., property rights, land ownership, that's a really huge issue. That's one of the foundations of the country, was having these rights. First, it was, we want this land from England, so we're going to take that. And then it was the expansion west. And these property rights and these land rights are just an essential piece of the fabric of this country. And, that's nothing shows that more clear, I think, than the treaties with the Indian reservations and the U.S. government at the time they were created. and the updates that came later too. So I think it's just very illustrative of kind of what the priorities were and are for the foundations of the country, in my opinion. And, others could argue otherwise, and I've heard lots of arguments otherwise, and they're absolutely valid. But yes, and it seems like there are some states and some treaties where the different kinds of Indian tribes have a different amount of pull, or have been, have been more able to say, hey, we've got a problem, and the government's been able to say, like, what can we do to help? So I think it depends also on where the reservation is located to some degree, although that would definitely be in the minority number of cases, but it does happen. The Iroquois Confederacy was a primary outline for the... Yes, it was. It absolutely was. And the Iroquois Confederacy was amazing. It was an excellent piece of law. Benjamin Franklin, of course, was incredibly fascinated by it. He was so inspired by it that he wrote those first initial Articles of Confederacy that were completely trashed. But it was, they had some really great points. I'm not sure how it could have really played into the current scheme of things at the time when the articles were passed, but yes, absolutely, it was the inspiration behind the articles. In fact, they weren't going to be called the Articles of Confederation until this idea of confederation came into play from the Iroquois. Absolutely. If you go back further, I'm sure peoples all over the world had bounced around. Yes. True. Absolutely. I think that there are some places that have governments that have been in place a bit longer, but I think that's true all over. I think, again, what makes the United States a bit unique is how young the country is comparatively, and because of how it was created when nobody thought there was even land here to begin with. So it's very interesting. Can only be tied. No, I don't think they can only be tied. I think it's going to depend. I think that it's good to be respectful of people's homeland, but I think also the nature of the world is to kind of conquer and take over the weaker link, unfortunately. So Marshall's first case said Indian nations are sovereign. Andrew Jackson violated the law of the land. He did. Andrew Jackson made multiple violations. And that's not, in my opinion, that's not even the worst that he did. Debated onto what exactly that sovereignty means. And because of how these treaties are written, the U.S. government has some kind of guardianship or some kind of fiduciary-like duty to the tribes, or keeping water in reserve for the Indian tribes. But what exactly does that mean? And so it's a big question about what this kind of sovereignty means when we've got two conflicting interests, but the U.S. government is supposed to be protecting the Indian tribes' interests, but yet the Indian tribes' interests are in conflict with the U.S. government, and that was one of the biggest questions that Justice Gorsuch had. Who's to say whose land is? There's no way to prove who owns what. Well, I think there's lots of ways to prove it, but I think the validity of the proof or what's allowed in as evidence is definitely in question. I don't think we're all playing with the same set of evidentiary rules when it comes to whose land is what. Andrew Jackson was honestly, yes, he was. He was indeed. There are a lot of situations where he is definitely one of the worst that we've had. In my humble opinion as a political scientist, to the side. The natives that were here before the settlers came here, I'm sure they took it over from others too. Oh, yes. And again, that if you go into a lot of, or several that I can think of off the top of my head, there are several tribes who have histories of how the land changed hand to hand. And that was one of the biggest problems and one of the reasons that it inspired the Iroquois to put together a confederacy, was to try to address some of these land issues. So many of the tribes did try to work together to try to establish this kind of agreement between them so that there wouldn't be so much back and forth between the land, but it was never really solid until, of course, a common enemy came into play. And even then it was difficult. And you have to realize too, I think we've got over 500 reservations in the United States. There are so many tribes and so many histories, and they are so incredibly individual. They're just very, very unique. And each tribe is its own creature. So to try to lump all of one side against another side was very difficult, as was shown, I think. Have you read The Great Law of Peace? I've not read that. I write that down. I have not. I'll have to take a look at that. It sounds very interesting. This was just something that was part of my undergraduate specialized area. I took a lot of courses and did a lot of work within the area of Indian tribes and Native American history. But that was part of my degree program that I really, really enjoyed. So luckily I've got a little bit of history to be able to rely on that. No, the Jerome Commission, I've not really looked into that, but I can write that down as my list of things to look at. I love to learn new things. This is a very interesting area of the law. This is not an area I specialize in, don't get me wrong, but it is an area that has so much litigation over the decades that it is very, very interesting, litigious area of the law for sure that doesn't really get the level of recognition that I think would be helpful. Of course, you probably didn't hear of this particular case coming down as much as some of the more recent cases. So, yes, casinos. Yes, absolutely. And that's huge. Casinos all across the United States have had all kinds of issues and questions about that. That still continues to be an issue. And even I'm in the central time zone, and even in my state, there are huge issues regarding location and taxes and all kinds of things like that are huge issues that tribes are having to deal with as they go through things. So yes, yeah, and it's interesting if you look and see the migration where it started from and all the different areas of the world that it wound up in. It's a fascinating area to study on how people got to different places, for sure. Very interesting to take a look at that. So, well, I am looking at the clock here and I'm checking. I'm probably going to go ahead and hop off here pretty soon. But I do have a couple of things on my to-do list. So I will be making a couple of posts on what are some of the best Oye cases to look up when you're looking for kind of the history of the United States Supreme Court, along with the history of the history of the United States Supreme Court and the different ways that our courts have held different kinds of cases as time's gone on. So I will put together a couple of posts on that and try to get that together. I'm going to try to do one live a week on an important U.S. Supreme Court case, at least one. I did already go through 303 Creative. There was a request to do the ICWA case, which is another interesting case that was handed down by the U.S. Supreme Court. Very interesting and historical case. But I do want you to know, if there are any cases any of you are interested in me kind of going through in this manner, giving the history and the background, just leave a comment on any of my videos, and I'll check through and see if anyone has any particular requests. I'm always happy to try to explain things as best as I can. This is kind of like an evening lecture for me, so it's a hobby that I enjoy doing. So if anyone's got particular cases they'd like me to go through, I'm happy to do that. Just let me know. But I probably will be going through the ICWA case next. I did already do Biden v. Nebraska. I've not done the Harvard case, the affirmative action case yet. There's so much case law involved in that, so I've really got to get more posts up about it. We'll see about that. I do like to kind of look at these cases that haven't hit the media as much, just because I think there are less resources available kind of going into the details. So I will try to get into the ICWA case probably next week, so stay tuned for that. And I will be doing some posts to follow up tonight's live. I have been starting to post recordings of the live on my YouTube channel. And I say that YouTube channel very broad sense. It really just is my lives that I'm posting. So if you're interested in any of the other cases that I've done in the past, or are interested in more of this kind of format, you can go. My YouTube is under the same name as this TikTok channel as well. Merrill v. Milligan, I haven't done that case. It's in my stack, so that would be very interesting. I'll take a look at that one. Absolutely. That was a good case. But thank you all for coming tonight. I appreciate it so much. It's always so enjoyable to talk with other people and just kind of explain things and read the Matthew Fletcher. Okay, I will take a look at that. But I just am always happy to share whatever information I can with anyone who is interested in it. So I look forward to chatting with all of you again in the future. And thank you again for your time tonight. It's been wonderful. So have a great night, and I will go ahead and sign off now.